Hi everybody, welcome to the first in our series on the Trump administration and effect on immigration, series part 1. Welcome everybody, I'm Cliff Rosenthal, I'm a partner at Wolfsdorf Rosenthal, an immigration law firm. And everybody knows, everybody's talking about it, whether it's in the session hearings, whether it's throughout the election, about the Trump administration, what they're going to do once they're in power, once they have control over the immigration laws. So everybody's a little bit worried, everybody is a little bit anxious, and we thought that we'd do a webinar just to discuss, in a 4-part webinar, where we're going to just discuss the various approaches that we can take in order to manage what may happen, what could happen, and what's likely to happen. So the first of the series is when the government comes knocking: immigration audits, labor condition application, LCAs, attestations, maintaining them, and site visits. This is really the first step in what happens, when the government comes knocking on the door. And this is the part that we want to be, we want to start first with, because this is really the part this is going to be the first thing that we're going to see people that are, that manage companies, people that are employees for companies, people that HR for companies. This is the first thing they want to know in this regard: what's going to happen and how it's going to work. Just as a disclaimer at the bottom, you can see that this webinar is not meant to be a webinar that discusses the minute details of every single case. Really, what this is, it's for informational purposes, to give you an idea of what you should know, what you should be learning, and just give you an idea of where you should be going in navigating this process, and really making sure that you're compliant in everything. So if you feel that you're going to be a black belt and you're going to know every single detail of every single immigration law, that's not really the purpose of this webinar. It's really to give you an idea that you can go forward, you can ask questions, and my details are at the bottom. Feel free to contact me or any one of the attorneys at our office that can help you. Not necessarily, just reach out, an email, not on the clock, and it's a resource that you should definitely use, and we encourage all of that. So with that, let's get going. Just a little bit about our company and our organization, our contact details, and everybody really knows, and everybody has heard about the wall. When dealing with the Trump administration immigration plan, everyone knows about the wall: who's building the wall, who's paying for the wall, who's not paying for the wall. And really the focus on the Trump administration immigration plan has really been enforcement. That means deportations, that means raids, all these kind of actions, and people really feel, and there's a lot of noise about it. The media really has really taken this, it's very focused on this, and that's really the immigration plan against what we call the undocumented foreign nationals. But really there's also a different part to this process, and this part of the process is really there's also another part of the process that focuses on U.S. workers, and everybody knows one of the main thrusts of the Trump administration was U.S. workers, and focusing on U.S. workers and how to improve their perceived plight. So in the immigration plan, there really there's no real specifics, on what they plan to do with legal immigration, but there's certainly some hints to that. And really, we'll see in a minute, there was a lot of media on the H-1B program, which has really felt the thrust of the media and of the Trump immigration plan. So if you look at the published immigration plan, there are two statements: one, that jobs are going to be prioritized, wages and the security of the American people, and then a plan to establish new immigration controls that will boost the wages and ensure that jobs are offered to American workers first. And that's really we're going to see is really the thrust, is that specifically the H-1B program is been seen as by the Trump immigration plan as a mechanism to hire cheap labor, as opposed in contrast, or at least at the expense of the American people. And then just if in Trump's 10-point plan that he published in his election platform, he wanted to say reform legal immigration. So that sounds like there's going to be some sort of real reform. As you know, there's a lot of noise. What's going to happen? What's going to happen and what's not going to happen. But certainly, it's very important to at least take the platform, the platform that is the platform, and take it at least at some sort of base level of what could happen and where they want to go. The last point of the plan, and most of the plan does deal with the undocumented, but on the last point, it does refer to reforming legal administration to serve the best interests of American workers. Okay, and I'm not going to go through all these quotes, verbatim, but you can just have a look on the quotes of the H-1B program. As I said, the H-1B program is really has formulated the thrust of the attack against what we call legal immigration, on reforming legal immigration. These are quotes that that have come from either the Trump administration, the team, or Donald Trump himself, and they really do focus on the substituting of American workers and the bringing in foreign workers at lower pay at the expense of the U.S. workers. For instance, there was one particular incident that happened at Disney where Disney employees were told that they had a few days to train their Indian replacements, and obviously that got very bad press and resulting in the quote that you see there below. Okay, some others. Recently it was published that one of the things that Donald Trump will do on his first day in office, one of 5 things, is he's going to direct the Department of Labor to investigate all abuse of visa programs. Again, this is just hinted at the H-1B program, but at the end of the day, this is really what's behind it. Okay, and then as going through the election, there has been some softening. There have been some give and take. Technology companies have said that that have in their mind asked Donald Trump, engaged him in order to protect the H-1B program, to protect legal immigration based on their perceived shortage. And we do have some softening, and there's a lot of noise, and we're really going to see what's going to happen. Some of the suggested reforms have been higher minimum wages. For instance, there was one bill that outlined that perhaps there should be 110,000 minimum salary for any H-1B, which is obviously, it's very high. Some specialties maybe not so high, but generally that's a very high minimum for many professions, and that would certainly protect undercutting the U.S. worker. There talks of recruitment, like green cards, in other words, to make sure that U.S. workers were qualified. Companies will have to recruit and then entertain resumes, and then have to explain why no qualified applicants were found. There have been thoughts to replace the lottery system with companies that pay high wages only. In other words, it wouldn't be random anymore, the H-1B lottery, but rather those companies that pay high wages would get better qualifications, more numbers. Another major a major issue in the H-1B program is the outsourcing. Outsourcing companies mainly from India that bring people over to the United States, and then they find other jobs for them, or they place them at other work sites. And this is one of the major critiques of the H-1B program, because their wages cut the wages of the traditional companies. And one proposal would be to ban the outsourcing of this, banning these outsourcing come from the H-1B program, such that that it would protect U.S. workers as well. And then some people have even said reducing the H-1B quota even further, which would at least in the minds of technology companies, and would create a major issue for technology employment in the United States. So those are really I guess the background to the Trump immigration policy, specifically where, as it's going to relate to the H-1B program, the temporary program, and visas and legal immigration. We do know there's a lot of noise. There have been a lot of quotes, saying how this was going to be reformed to protect U.S. workers. We've seen some softening, but what we really do see is that we might not know the exact details of what the reforms will be, or even if there will be reforms. But I think just based on the tone, based on the tone of the campaign, the tone of the immigration platform, we can be pretty sure that there's going to be a focus on compliance and enforcement. And what that really means is that we're going to see a lot more audits, a lot more investigations, and a lot more site visits. And most of these will, most of these site visits can result in monetary and even criminal penalties. But at the end of the day, people have to realize that we live in a very regulated environment, and you really must learn the law in this regard, because it's so easy to be in violation of the law, even if you're not in violation, even if you don't know that you're in violation. In the old days, you could rely on the fact that my immigration lawyer he gave this to me. We'll put it in the employment file, and we don't have to worry about it. Everything's been taken care of. But in today's world, everyone has to be an expert. Not only the immigration lawyers. Of course, you have to work with the immigration lawyer, and you work together to create plans and to create efficiencies and to make sure everything is in order. But it's really critical that everybody's aware of the different requirements, and many of these requirements are continuing, and they don't just happen at the beginning of the application. It's not the application gets filed, gets approved, and you don't have to worry about it. Many obligations are continuing obligations throughout the application, the life of the application. And if the H-1B is 3 years, you have to be in compliance for 3 years, and you have to make sure that no changes happen, for instance. And if changes happen, you have to deal with those changes, because you have to be aware that there's going to be enforcement and compliance. There are going to be people checking up on you. Everybody who has an H-1B, probably an L1 visa as well, and maybe some of the other visas as well, is going to should expect a site visit, someone to check up on them, check that the application is correct, that it's truthful, and that all the obligations are continuing. And it really is a scary thought to realize this, and to have this responsibility. But it's really critical in today's environment, because it's only going to increase and increase and increase. Is our understanding. Reforms such as changing the laws, those are always much harder to enforce, much harder to complete. Simply have to go through Congress. They've various levels of review, but focusing on compliance and enforcement is certainly a much more ready way to move forward, and we really do expect that the administration will move forward with these. So with that in mind, I just want to go through a couple of examples, just of the type of the type of audits, the type of the type of regulatory environments that we have to navigate. And again, the idea is not that you'll be a black belt at every single point. But just a kind of idea. This should give you a kind of idea of the things you just have to focus on, and this is something you really have to focus on, because, as I mentioned, you will need it. So one, at least in the H-1B process, the labor condition application is one of the main sources of audits, of penalties, of violations, whether technical or even fraudulent. A few years ago, there was a particular immigration. They did a report that said 1 in 5 H-1B applications either had some technical environment or technical violation or fraudulent violation. So certainly in the H-1B process, most of the violations do come from the labor condition application. So just want to spend some time a little bit on that, just to give you an idea of the kind of things that you have to be aware of. So the first one and the major and the most important one is generally paying the wage rate. For the H-1B, there's a minimum wage rate. You can't pay the application lower than what other workers would be paying. And one way to do this through a union. If you have a union, that would be the required wage. Otherwise, you have to pay them the greater of the actual wage and the prevailing wage, the wage that you actually will pay them, and the wage pay them or other workers, or the prevailing wage, a minimum wage that is set by some sort of qualifying survey. And this is a continuing requirement. You have to make sure that you keep paying the person this wage, and you cannot stop paying the person the wage. You cannot go below the wage. You may able to do amendments and various things, but you do have a requirement to pay a continuing requirement to pay this H-1B employee this wage. There are also requirements on what information must appear on the payrolls. So these are detailed in the regulations. I'm not going to go through each requirement, but even the point is that even the payroll records that you have to keep in an H-1B application, even those that have distinct requirements, and you have to keep very specific information that might not be the same as your payroll company or the general information that you use. The requirements as to how and when the wage should be paid. There are requirements of what deductions are legitimate. In other words, you can't just decide, well, I'm going to deduct a certain deduction because that might be a company expense that would reduce the wage. So there are very detailed rules on what deductions you can deduct from someone's paycheck. The requirements of paying a wage during non-productive status. What happens if the person is sick or takes a leave of absence, or has a maternity leave, or what happens if you've got no work for this person. These are very important concepts, and there are lots of rules relating to this, so that when if an officer comes, site visit or investigator comes, you want to make sure that you're in compliance, you haven't done the wrong thing. There are restrictions on penalty clauses. For instance, if an H-1B ends his employment early, you can't say, well, he's got to pay all the money that they paid for immigration fees, for legal fees, for government fees. And in many cases, if you reimburse, you have to reimburse the foreign national, and there could be penalties. And if this is systematic over a certain large number of employees, then it can become hefty fines very quickly, especially if they feel that that you were reckless in not obeying the laws. So just some of the other attestations, distinct from the wage. Yeah, the H-1B has to get the same working conditions as U.S. workers. Similarly, the U.S. workers have to get the same conditions as H-1B workers. In other words, you can't use benefits to undercut the U.S. worker or the H-1B worker. You have to show that you have to test that there's no work stoppage, no strike or lockout, because you can't be hiring a person just because the union went on strike to try to replace them. There are notice requirements. You have to put everybody on notice, posting at the work site, providing notice to the unions if there's a union. And again, even in this, there are lots of requirements. When and where, how, what to post, and these are all types of things that officers and investigators look at when they come and they audit you, and they want to see your filings. You have to provide the LCA, the labor condition application, to the H1B worker before they start working. If you want to put somebody on short placement, H1Bs are typically linked to a particular work location. So the detailed requirements on how you can, paying wages when the person's on a short-term placement, how at another location, how long they can be there. You have to pay their lodging and travel and food expenses, even though you wouldn't be able, you wouldn't typically do that with other employees. And then if you have too many H1B, or if you have a higher percentage of H1B workers, there's some special requirements. You have to say that you have to show that you've done some recruiting for the position and make some extra attestations that you're not displacing U.S. workers. So these are all things that are checked. The major way and the major requirement in terms of checking, of investigating, is what's called the public disclosure file, sometimes called public access file. And really, this is a file that has to be kept open for the public, and has to be, it should really be part of. It should really not be part of the employment file, because there's specific requirements, and you want to make sure that you meet the requirements exactly. You don't want to put in other documents that may have some some bearing on the application that are not required to be there. So the major point is you should really keep this independent from the employment file, and this is really a file that has to be kept open for public examination. Anybody can do this. And it has to already be the one working day after submitting the LCA. It has to be maintained for 1 year past the date that the employee is employed under the LCA. If there's multiple employees on the LCA, the last employee, even if the LCA was never ever used, you have to keep it for 1 year after its expiry or its withdrawal. And then you can look at the kind of things that have to be included, and they match what we just mentioned in the LCA attestation requirements. It must be, you have to have a certified LCA in there. You have to show how you worked out the wage. In other words, the actual wage in terms of what the employee will be paid, what other U.S. workers are paid, so they can match. You can see that there's no substantial difference. How you worked out the survey for the prevailing wage, proof that you satisfy the notice requirements, the benefits, proving that the benefits are equal to H1 employees as opposed to similarly situated U.S. employees. If there's been some change in a corporate structure, that has to be detailed in there, and finally, if you're one of those companies that has is dependent on H1Bs, have many H1Bs, high percentages, those extra requirements have to be shown there as well. It's also recommended that you have, a different file, and these are not for public examination. They're not required to be shown to the public, but they are required to be kept in case of investigation. If an officer can knock on your door and they can say, "I've come for these documents." Again, these should be separate from the employment file, because the employment file just has a lot of different things that you may not want to show to the officer, but ultimately, these are documents that are part of the record, and they should be available to officers if requested, even if they're not available to the public. And that includes copy of the H1B petition, payroll records, and they're very substantial payroll records. You have to show, at least for the 3 years of the LCA, and as well as other, the other situated U.S. workers, to show that there's no discrepancy with that. A memorandum showing, that the certified and signed LCA was given to the employee before the start date. Proof of the documentation of fringe benefits, what they took, what they didn't take, to make sure that these were that these these were consistent with U.S. workers. So these are things that have to be kept, and they could be and they could be asked for, and they are asked for. So it's just just something that you have to be cognizant of. And then just generally, for those that want to see just the consequence of non-compliance, you can see there's some hefty civil monetary penalties. It depends always. It depends if it's a technical violation, it's a fraudulent violation, is obviously much more serious. How widespread the violation, how long the violation is. Back wages can be required to be paid, and they can go up very quickly. If you're not careful, you can be disbarred from the H-1B program. It's a 3-year. There's regulations bring a 3-year disbarment of possible action. I-9 violation, that's really going to be a subject of a different one of these webinars. But I-9 violations are have their own sanctions. It could be criminal sanctions if it's thought that there's some sort of fraud involved, some sort of animus, some sort of intention to either hurt the H-1B or the U.S. worker. And you just have to be careful. Audits can be random, but they can also come from reports, disgruntled employees. They could be U.S. employees. They could be the H-1B themselves. So it's something just to be careful. And then that really deals with the with the LCA and the Department of Labor audits, but the H-1B also has a different part run by the USCIS, the U.S. Immigration Service. And what they do is USCIS. What they do is they visit sites randomly in order to check on and verify the truthfulness of petitions. That what you put in your petition when you filed your application, is that true, and is that continuing? Has the eligibility changed, or is everything pristine as it was at the beginning of the application? And we see these mainly in H-1B and L-1 petitions, and these are what we call post-adjudication site visits. They're after the application is approved. The R1 religious worker petitions, it's a little different. It's a very high fraud category, and they actually do the site visits before adjudication. There are some triggers. They're supposed to be random. A few years ago, a memo was leaked that seemed to indicate there were some triggers. Usually, if the application was done on is an extension, you're on a higher, there's a higher propensity of getting one of these site visits if you have a certain amount of less than a certain amount of employees, less than 10 employees. If you have less than a certain amount of annual revenue, 10 million annual revenue, that might be triggers. There are at least the current triggers are at the moment they are private. They're not released, but that's something to just to keep in mind. So what really happens in this process is it's all part of what's called a compliance review, and the site visit is, I guess, a component of a compliance review where USCIS will check the veracity of an application and continuing eligibility. So what this really includes, it's researching information in government systems, looking at public records, looking at the petition, and then the main part of the site visit is interviewing the petitioner and the beneficiary, and then getting any payroll information, any other information that could impinge on those interviews. Participating in a site visit is voluntary. People always ask, do I need an attorney? Do I have a right to counsel? Immigration's view is that this is not really a legal proceeding, and there's no right to counsel, but there's also no right, there's no obligation to participate either. You can say, no, I don't want to participate, and you're quite in your rights to do that. If you do that, all that would mean is that the compliance review would be completed based on any documentation that was able to get from other avenues. So you put the application at risk in the sense that excuse me, that you won't have the opportunity to to participate and show that the application is truthful and that you're continuing to work to hire the employee in accordance with the petition. So sometimes the officer will allow you to call attorney. Usually they don't, and it's considered a much more of a voluntary application that you have the right to choose or not to choose. Any point, if you decide to participate, you can always terminate the visit. You can tell the officer or the inspector that you don't want to complete this anymore, and they will again complete the report with the data they have. Very, very often, the compliance review will result in a follow-up. Either it could be a phone, email, or fax. Usually today it's normally email. And they'll ask for certain documents that will corroborate anything that was said in the interview. And I think that since this is a process that's you have to email them, it's in writing. I think it's a very good idea to use an attorney in this regard. Certainly check it out with your counsel, and make sure that everything is correct and reviewed. So after the inspector completes the compliance review report, then they will report that they will report back to USCIS, and then they will recommend appropriate action. Could be a revocation if the application is not truthful in any manner, or if there's no continuing eligibility, then they could revoke it. Otherwise, the application will be confirmed, and you won't hear from them. Site inspectors are really just investigators. They're certainly not adjudicators. They don't really know too much about the immigration process. They normally have a list of questions, a list of documents, a list of things that they want to do, and then they report back the facts, and the facts are dealt with by USCIS, and the consequences follow from them. So just looking, standard anatomy of a site visit, the kind of things that that a site inspector may want to do. They certainly verify information in the petition, see if the organization exists. Maybe there's no organization anymore. Look at the public records, information on the petitioner, make sure everything is consistent. Unannounced visit that we've been speaking about. Sometimes they want to take photographs. Sometimes they want to take a tour. Certainly, they want to speak with the employer, and to test and to confirm all the information in the petition. And then they usually want to interview the beneficiary as well. And then finally, request additional documentation is needed, and that's usually payroll. So I think the most important part of strategizing for a site visit is just to be prepared, just to know that it's going to happen, and just to have a strategy, just to have a plan, so that when it does happen, then everything can go smoothly. And I just listed a couple of points, that I think are extremely helpful in just making sure that that they go smoothly. Assuming everything's truthful in your application, you follow this advice, then there should be no real issue in responding and participating in one of these site visits. I think the most important thing is to really designate in advance who's going to be the employer representative, who will handle the site visit, who will handle the questions, who will handle, managing the site visit on behalf of the employer. And I think it's also very important, and it's really the corollary, is that all other staff members should know that this might happen. A site visit that could happen, and they should refer any investigators to that particular person. I guess the major issues happen when the site inspector comes and they see the receptionist, and then the receptionist starts talking about the petition, especially things that they may not even have any knowledge about, the mistake, something that they may think is correct, it's not correct. We've seen cases, for instance, when a reception said somebody didn't work at a particular place because person worked on night shift and this person wasn't there on night shift. So all sorts of problems happen, from not controlling the situation as much as you can. So certainly designate an employer representative, and then make sure that that the other staff members are aware and that they at least know who to refer the investigator to. The employer representative, the person handling the interview, should be familiar with the contents of the petition. They should know the major part of the petitions, which foreign nationals are, what their positions are. Obviously, they don't have to know every single detail of the application, especially if in a company with a lot of foreign nationals. They don't have to know everything, but they should be able to. They should have the major information in front of them if they can. If not, they should certainly have lists and access to that, to the contents that the officers would ask for, and that's mainly the petitions. And so they would be able to know that this petition is in this place, and they needed to see the person's job, confirm the job duties and salary. They would be able to have access to that pretty quickly. It's also a good idea to provide the beneficiary, the H-1B employer, or this could be an L1, the employee, with a copy of the petition. And they're going to be interviewed as well, and they should be able to communicate the essential parts of their interview. They don't have to know so much about the company. They may not be privy to all the details, but they certainly would know about their job and their credentials and their qualifications, their hours, their wage, etc. Always check the officer's credentials. Make sure you document them. Make sure the person's for real. If the officer sometimes wants a tour, wants to see the company, that's usually fine. But just make sure that that the officer's accompanied at all times. Take detailed notes. Make sure that what questions were asked and how you answer, just to make sure. Again, the officer is not the site inspector is not an immigration officer necessarily that's going to adjudicate the petition. So things maybe get lost in translation. And then finally, if you have outsourced position, if you've got an H-1B with a company that's working, on your location that's been placed, obviously those require, very acute care and very detailed. You really have to know who's working where and what they're doing. Just because you might not even know, that the application has been, the application has been filed. You might not know that you're not knowing it's been approved. You might not know anything about the application because an outsourced petition is going to be a different petitioner. The company's not the petitioner. So in those cases, you have to be very, very careful. You have to be really on top of the H-1Bs and make sure where they are and what they're doing at any time. And you should really put a lot of effort into that, especially in these ones. And then just the type of questions, I guess it's just before we go into the type of questions, just the general type of strategy in answering questions. You never want to answer a question that you don't know. Don't guess an answer. It's not like a test where you'll get points if you're lucky. You want to make sure really that you know the answers, because you're going to have to stick with the answers. So you want to, if you don't understand a question, ask. If you don't know, just mention you don't know. They can always ask, follow up in an email, fax, etc., as we saw before. And then the type of questions you just want to be, you want to be very aware of, the type of business, You want to make sure it's the same as the petition, the annual revenues, number of employees, locations, everything should be consistent with the petition. In terms of the petition and actually the position, they're going to ask about the job title and the duties and the salary, the work location, the job requirements for the position, how many hours a person's working, who paid the fees, their requirements, H-1B requirements, as we foresaw at the very beginning with the LCA, who can deduct fees, can the petitioner deduct fees. If it's an L1, they're going to ask about if the person's a manager. If it's an L1A, is the person a manager, who they supervise, what they manage. If it's specialized knowledge, L1, what's the specialized knowledge, what they're doing, and they want to make sure that's consistent with the application, with the petition. And then asking the beneficiary, obviously the thing the information in that domain. They're going to, hire date, qualifications, make sure that the person's still employed. So those are, those are very, very important. And the key is really just to make sure that you're consistent with the petition, and that that it can be communicated in a way that satisfies the officer. In terms of continuing eligibility, we mentioned you really have to continue. You can't just be, it can't be just truthful at the beginning of the application, but there's certain continuing obligations, and these are is one area that also causes a lot of issues in site visits, because when things change, they have to be documented, and if they're documented, they have to be documented in the file, and then they have to get to the person who's going to be the employer representative, who's going to handle the interview, so that everything moves seamlessly. If you haven't planned and your records are in chaos, then you're going to land up with these changes not being communicated and not being available to the site visit, and it's going to look like you're in non-compliance. So the main thing we see are changes, and generally if it's a minor change, these aren't considered material. There's no real consequences to that. The person's salary just increases an annual salary. That's not something that you need an amendment for, and it's certainly not something that's going to trigger issues on a site visit. Some promotions, if it's what we call a natural promotion, the person went from a software engineer maybe to a senior software engineer, then generally those, the job duties didn't really change, but it's just a kind of a title change or some sort of cosmetic change or minor job change. Those are not considered issues that you have to keep continuing eligibility. Change in the employee location depends where it is. If it's such that it would change the prevailing wage of the application, then you would have to amend the application, and that's usually if it's in a different metropolitan statistical area. In that case, you'd have to do an amendment H-1B, and therefore that would have to be present when at the site visit. If it's got the wrong address, not only the person going to go to the wrong address, but the person's not going to, the employee's not even going to be there. It's going to look like they're not employed. Generally, material changes in job duties could be going for hours, going from part-time to full-time, full-time to part-time. Major changes in job duties, the person becomes non-productive, they're not working. If there's corporate restructuring, all these should really be taken care of, because when it comes to a site visit, sometimes even if amendment's not a requirement, it's a good idea to do an amendment, simply because preparing for the site visit, the officer's going to come and he's going to see inconsistencies, left, right, and center, and it's going to be more difficult to go through all of them. It might be easier just to amend the application, and obviously if the person's terminated, the employee is terminated, then that should be communicated to immigration as well, to avoid the site visits, and there are obligations on termination as well. So just to end off, what I want to do is just show you one of the email credits. This is from an L1 application, and it's a sample of an email asking for I guess an email site visit to send these documents to a particular officer. You can see the kind of requirements, kind of components in this. They want to see pay stubs, they want to see W-2s, job description, an organizational chart. This is for a managerial, current salary, current location, who you supervise, foreign employment. All these kinds of things are certainly fair game, and you can see the format. You're given a certain date to respond by, etc. And then that's for an L1 from U.S. immigration. And then similarly this is one for an H-1B. This was based on an email. It's over 3 emails given the size, but you can see that the routine. This is a follow-up on an actual site visit at a particular company. In this case, they actually said that they couldn't reconcile the beneficiary's gross salary, that they would be paid enough, and after that they just, they ask for something specific to prove that by the end of the year they would be paid the prevailing wage. And I think, just to end off, just to kind of to reiterate where we're going, that in the Trump administration's plan, there's really going to be a focus on enforcement and compliance, and the key is really to be ahead of the game and to prepare and to plan and to strategize. There may be lots of reforms, actual substantive reforms in terms of the H-1B. How are they going to change it? Are they going to change the program, the quota, the requirements, the wages? That may still happen, but one thing you can be sure of is that in terms of compliance and in terms of site visits and audits and raids, these are going to they're going to increase, and it's really an opportunity to get now, is to prepare now so that you're ready for them, and when you're ready and you've taken care and everything's in order, that's the best way to respond and make sure you're in compliance. Thank you.